Hey, welcome to today's video. I'm Richard Chapo. I'm a privacy lawyer down in San Diego, California. So today we're taking a look at the California Consumer Privacy Act and the ADA injection. So the California Consumer Privacy Act is obviously a new California privacy law that goes into effect January 1st, 2020. The ADA is the Americans with Disabilities Act. It is a federal law that has been around for 3 decades now that addresses the disabled's ability to access services and goods and locations. It's obviously a bit more complicated than that, but let's just go with that simple definition. Now, the question that we're running into is there an interaction between the CCPA and the ADA that businesses need to be aware of? Initially, the answer was no. However, we've had some developments that might change that. Now, unfortunately, I'm going to have to explain some things about the ADA, a little background here, so try and stay with me. The ADA, when it was passed, I want to say it was 1990, maybe a little earlier than that, but it was passed before we had the commercial internet as we know it. If you remember, like 1996, everybody was still on dial-up modems, the horror. But when the ADA was passed, the Department of Justice was charged by Congress with issuing regulations, and it did. And these regulations were basically efforts to tell businesses, okay, on a day-to-day basis, here's what you really need to do to comply with the Americans with Disabilities Act. And so it did this for all the brick and mortar businesses. As the commercial internet became more viable and it became more, larger part of our lives, businesses and attorneys were waiting for the Department of Justice to issue regulations for the ADA in relation to this new online world. Does the ADA apply? If so, how? What do we have to do? And we waited. And we waited some more. And we waited. And every year, the Department of Justice would issue a notice saying, this is the year. We promise we are going to issue regulations. This went on year after year. It was just kind of a running joke until finally the Department of Justice said, we're not going to issue regulations. Really just kind of a disaster, to be quite honest, because, as a business, you just want to know what you have to do. And this created, a lot of ambiguity in the area. So at this point, as you can imagine, the only avenue left for trying to figure things out was through court cases. And so we had cases where disabled individuals would sue businesses, the courts would rule, and we would get these various rulings. And the short and sweet of it is we have a split in the law. There are 13 circuit courts. These are the federal courts in the United States. And 4 of them, well, there are 2 sets of rules that they've come up with. So let's just start with the first one that everybody agrees on. If you have a website or an app or any kind of online platform, and you have a corresponding physical location that's providing essentially the same thing as the online platform, then you must comply with the ADA. So let's talk an example. You have an e-commerce store. You're selling clothing. Okay, well, if you also have a store in a mall selling the same clothing, same business name, the whole deal, then you have to comply with the ADA. And all courts agree with this, every court. So it's just a set rule. The question gets a little more muddled, however, where we have an online presence with no corresponding physical offline presence, no brick and mortar store. So let me give you an example. I'm a big hockey fan. I have a hockey blog. No, I'm not telling you the name of it. But I don't have a corresponding physical location. It's just a hockey blog where I get on there and, rant like a crazed fan about various aspects of the NHL. So do I have to comply with the ADA? And if so, to what extent? And the courts have struggled with this, to be quite honest. And so we have the 13 circuit courts. Of those, 4 or 5, last I'd looked, it was 4, had said, it doesn't matter if you have a physical location. You still have to comply. If the disabled have the right to essentially access your website or your app, then you have to comply with the ADA, and that's it. However, 9 other circuit courts have said, well, the ADA doesn't apply. You don't have to comply with it if you don't have the corresponding physical location. So for my hockey blog, obviously I don't, so I don't comply. And of these circuit courts, well, now you might think that this is a strange approach. This actually happens all the time in law. And usually the way that it's resolved is either through legislation passed by Congress, which, wouldn't hold your breath on that, or the Supreme Court taking up the cases and settling it. and coming up with one view, one set of rules. We just saw this last year with the online internet sales tax issue, where the Supreme Court took up a case involving South Dakota and issued one set of guidelines. And that resolved everything for all the different states that were passing different sales tax laws and all the chaos. So recently here, we had a case brought by Domino's that was appealed up to the Supreme Court. And they were looking for clarity on this to decide this scenario and set one rule. And unfortunately, the Supreme Court said no. They did not take up the case. So we're left with this kind of mess. And probably for, at least the next 3 to 5 years, I would imagine. The Domino's case was kind of a prime case to take this issue up. And for whatever reason, the Supreme Court didn't do it. So what we end up with is the split. Now, the Ninth Circuit Court includes California. And so a lot of businesses in California, except for the huge ones, Google and these kinds of groups who just are ADA compliant, but a lot of the smaller businesses who can't really afford it have taken the view, hey, we're one of the circuits that doesn't, say that that says the ADA doesn't apply if there's no physical location, we're fine. Okay, so with all that out of the way, the issue we're having with the California Consumer Privacy Act isn't so much the act itself, it's the regulations. So the California Attorney General is charged with issuing regulations so that businesses will know what they have to do, on a day-to-day basis and in detail to comply with the law, because the law itself is just kind of this bizarre mix of text that's kind of all over the place, really poorly drafted. And the new regulations came out about a month ago. It's the first draft, but they contain an interesting addition to what we were expecting. Essentially, they say that any pages and any functionality that you complete in relation to the California Consumer Privacy Act when you're trying to comply with it must also be accessible by the disabled. Or you must provide, at a minimum, an indication of how the disabled can access these pages. The ADA is not specifically mentioned, but right now we really only have one set of guidelines as to what compliance would essentially be, if you will, in relation to giving the disabled access to websites. And those are regulations that were issued under the ADA. They're not regulations, they're guidelines. We don't even have regulations. It's just guidelines that an independent group came up with that everybody follows. And I just forgot the name. I believe they're called the CWAG 2.0. There are 3 different tiers, and it gets complicated. But the practical aspect of this is that when you're creating your do not sell information link, your do not sell, your opt-out page, the page where your California privacy notice, where you're giving individuals, an update as to what their rights are and what they can exercise, their right to delete page with forms, all these things have to be accessible to the disabled. It is essentially an ADA requirement for these pages. Now, not specifically, and there's room to argue about it, but you're going to have to do something to make these pages accessible to the disabled, people who are blind, people who are deaf, whatever it may be. And it isn't entirely clear how exactly that's going to work, but a lot of companies seem to not be aware that this new requirement exists. Now, it should also state that a violation of the California Attorney General regulations, the CCPA regulation, is considered a violation of the CCPA. So it is the same thing, if you will. It's not like you can say, well, it was just a regulation we didn't deal with. This area is just ripe for all kinds of lawsuits. And although the California Consumer Privacy Act is primarily restricts enforcement to the California Attorney General, you could see ADA lawyers looking at this and thinking, they may be able to create some type of an ADA claim based on violations of the CCPA. There are all kinds of different ways you could go. The claims of unfair business practices and what have you. And that gets into other areas that we probably don't really want to cover in this video. But there's a potential out there that this could be a boon for ADA lawsuits. So you want to make sure you talk to your attorney and discuss how this is going to impact your CCPA compliance efforts and make sure that you take it into account and deal with it. Now, the bigger question then becomes, well, if you're going to make these certain pages on your site CCPA compliant, should you just go, or ADA compliant, essentially, should you just go ahead and make your entire site or app ADA compliant for practical purposes? That's a decision you'll have to make. But I mean, For a lot of businesses, it kind of makes sense to just do it. So make sure you address that issue. Now, one final thing, there is a 30-day cure period in the CCPA. And I've been hearing a lot from people about, we're not that worried about violations. We can cure them in 30 days. Yes, but also no. If your violation is causing some kind of harm or damage, it's not clear that just because you fix it in the 30-day period, that you're off the hook. So for instance, let's talk about a data breach. Let's say that your secretary gets an email from a highly credible prince in Nigeria about his uncle, who is the oil minister and has $35 million, and he really needs to transfer it out of the country. And could you provide the business bank account? And they'll send it on over. If the secretary was to mistakenly agree to that, and by the way, it has happened many times, in fact, including a $300 million proposed airport in Brazil that didn't actually exist. But let's just say your secretary made the mistake and complied with that request, and suddenly a virus is downloaded to your computer system. There's a data breach. Your entire customer database is stolen, and you're in violation of the CCPA because you don't employ reasonable security practices. The 20 CIS controls. Okay. Well, how are you going to fix that in 30 days? You may be able to employ the security, but the problem is that breach is already occurred. All of your customer information is already gone. And the fact that you subsequently fix security isn't going to relieve you from the liability for that. So, I'm not suggesting the 30-day cure period is a bad thing. Just think that through. It's not the cure-all that everybody seems to think it is. And you don't want to, fall foul of that or rely on that and then subsequently find out, we have a problem. So ultimately, the ADA is never mentioned anywhere in the California Consumer Privacy Act or in the California Attorney General proposed regulations. Nonetheless, it is important to understand that any CCPA compliant documents must be accessible to the disabled, well, most of them. So make sure that you talk to your legal counsel and you get your act together in that area so you don't walk into a significant violation or even a potential lawsuit brought by a creative plaintiff attorney over a de facto ADA violation. So anyways, if you have any questions or comments, feel free to contact me at socalinternetlawyer.com. You can also leave a comment below if you'd like, although please keep in mind it is a public forum. If you're looking at this on a public website, then there is no attorney-client privilege. If you enjoyed the video, give me a thumbs up. If not, I feel shame, give me a thumbs down. And that's about it. Thanks for watching.